And welcome to Justice Served TV. Finally, we're making some progress in the Kelsey Fitzsimmons matter. And what about this teacher and the shooting by the 6-year-old? This is a case, let's just say, I think we're going to learn a lot from it.
Love you, love it.
In the courthouse the other day, in the hallway, you're singing, "Oh Happy Day."
Drums of war beat through the night. Victory, oh what a sight. Oh brave souls in the storm, raise your swords, no more to mourn. Giant hearts in battles born, legends forged and never torn.
Well, I'm going to have to turn that down. Have to turn that thing down.
Yeah, I don't know. That'll wake you up. You know, that's our warrior song. It used to be used for Person of the Week, but you know, I've been pushing to use that song, as you know.
Yes, well, then you must be behind you must be behind
No,
the attack on our original song. Anyway, yeah, I'm going to dial that audio down. It's interesting on StreamYard, you can't do that while it's operating. It basically takes whatever you upload and says, okay, that's the volume. So I'll reload that at a little lower volume.
Okay. All right. Okay. Well, now that everyone's awake.
Yeah. Linda Kenney Baden, how are you?
I'm doing well, Michael Bryant. I'm doing very well. Before we get into the video, I'm doing well. I don't have to wear a bag over my head anymore. You know my Jets. Oh, they just traded away 2 of their best players.
Are you kidding? Already?
They did on the trade today. But Sauce Gardner, okay. And Quentin Williams, but they have a first-round pick in 2026, a second-round pick in 2026, a first-round pick in 2027, a first-round pick in 2027, and they gained a wide receiver and a defensive linebacker. And the wide receiver was a second-round pick 2 years ago. So they did pretty well. As a matter of fact, this is kind of a haul. I'm kind of proud of them because while Sauce and Quentin were fabulous players, by the time the Jets get good, they'll be like old. So why not get some draft capital and just break it all up and rebuild it from the bottom?
All right. Well, I hope the fan base is as optimistic as you are. So, yeah. That was almost a rip and read you just did there about the Jets, but
I know, and it was green too. Really. Just to notice that it's everything is green. You know, like our rip and read is green and our opening is green, and our Justice Served TV is green. We're like Kermit the Frog. We're green.
We're green. Yeah, we're green already. Okay, what do you got there?
All right, rip and read. All right, I have things to load up, but I think we could just rip and read it. And one of them is a little bit older. It's, as you know, it's Commissioner Cox, and I only want to mention it is that Commissioner Cox, when he got called on the line about being on the, as you know, the Brady list, or Alan Jackson asked him to be on the Brady list, he said, "I don't ever want to hear these questions again." Well, Commissioner Cox, after what we learned through Ted Daniel, and the reason why, because this is really my rip and read. Ted Daniel yesterday had a program on it. He's the great reporter from Boston 25 News. I mean, I called him a beast today in a good way on X Twitter. He found out when he was investigating his FOIA requests about Proctor and all, that somehow Proctor was like, his car would start, but it'd be like tracked for 8 seconds in his driveway, or he never left his driveway. And he learned through this that the troopers are allowed to flip a switch, just like we are. The troopers are allowed to disappear, okay, in their troop car, if they have a sensitive case, and that doesn't take much for them to say it's a sensitive case, and disappear. So you may look to see if Trooper X is at a certain location at a certain time, and Trooper X's car won't show that it was there. Why? Because it's been hidden from everybody. It's like the stealth jet. And so that's why I mentioned that, because Commissioner Cox, you have a lot of problems. Alan Jackson, who was on our show just last week, I think he's kind of like started the takedown of the Canton PD. We had Sergeant Good yesterday, and of also the Massachusetts State Police. Okay, so that was, I have 2 more if you want.
Oh,
Really
sure.
one. That was really one.
That
Okay.
was really one.
Mark Sanchez, subpoena's been issued. Okay. In Toll versus Sanchez, which means it tells him that indeed there's finally this case and he's going to have to answer it. There's a civil case. And if he doesn't answer it within 30 days, guess what happens? Or 20 days, guess what happens? A judgment is entered against him. So at some point, he's
That's
going
gonna
to
happen.
answer it.
This is, of course, Mark
Yeah.
Sanchez, former Jet, current commentator, or at
Notice
least
how
was commentator.
you notice how my rip and reads have a theme to them? Okay. All right. So that's going to happen.
Losers?
Very funny, very funny. Two quick more. Matthew Farwell, who we reported last week, who was re-indicted for the death of the child, for the death of the baby. Well, his supersedious indictment was just issued today, and he's already waived coming in to appear on it. He's going to plead not guilty, but it's issued. If you want to read it, it's there. And finally, I just had to print this out because we haven't heard much about him, but Sean Combs, aka Puff Daddy, okay, or aka P Diddy, okay, or aka Love, according to the order here. Well, guess what? His appeal has been expedited. And I bring that up because we're going to be talking about Kelsey Fitzsimmons and how difficult it is to get her heard in front of a body. And yet, Sean Combs, all right? I just
is that a federal versus state issue or something else?
Well, it's a federal issue, but it's going to be heard in April 2026.
So that's expedited. That's expedited.
Right.
That's the justice system expedited. Okay.
Yeah.
I had a couple things I was going to talk about. One of them is very important, and it was because I had a question the other day that I couldn't answer, and it had to do with the rat czar in New York City. Remember? I remember very clearly when Eric Davis said, we got a rat czar. They brought her in. Well, she's gone. She's gone. She retired.
Oh,
she retired. She retired about 2 weeks ago. She retired about 2 weeks ago. She was getting 170,000 a year. That was her deal.
Oh, what a pension! What a pension that's going to be.
Didn't work out, and she said, "All rats," and she left. And
this is why people hate politicians, right? This is why people, what they do is they see as grift. And I don't know if she's grifting. She may not be, but they see it as grifting.
Well, Eric Davis said the rat count is down. Rat count is down, and we're going to continue efforts, blah, blah, blah. But anyway, that was really just for me to answer my own question. Her name was Kathleen Karate. Not that kind of karate, but she was.
I wonder we haven't heard about the rat czar.
And then one other thing on a legal personal, in the case against the Massachusetts State Police by both myself and Tom DeRozier, still going. The case is still going. There's been no resolution. We're slowly marching toward trial, perhaps. Which would
remind everybody what that's about, Michael.
Of course, is the trial, the case against the Massachusetts State Police, including Mr. Harding, who let's just say would throw his weight around in front of the Dedham courthouse there during the Karen Reed matter, stopped me from reporting, stopped Tom from reporting, accosted one guy, and his case that's the guy who had the sticker on his lapel, and it was ripped off. That case is a separate case, and that's also still moving forward. So all the stuff that we did that opened up the area in front of the courthouse so that we could all be there and experience what was the ultimate perfect acquittal -1 charge. We weren't able to do that if we hadn't brought these lawsuits and opened that thing up. So all of the work that Aidan Carney did to bring light to this thing would have been sort of snuffed out because Judge Cannoni had created that buffer zone, and we wanted to turn it into a First Amendment zone. We did, but the cases still continue, and they had a status hearing most recently, but nothing of any real substance occurred. So it will continue on. Okay.
April 1st. I remembered April Fool's Day, April 1st.
It was April Fool's.
And we were on the air. We were young'uns then in the Karen Reed case, so to speak. Right. And there you are. All of a sudden, you were a plaintiff, and I kept saying to you, "Why don't you just get arrested? Take one for the team, Michael." But nothing.
I tried, but I would have had to punch somebody, I guess.
Probably.
Speaking of that, and it was funny because when I was putting together the new version of the Open, which looks a lot like the old version, except for the music. I was looking at the video we showed Alan Jackson last week, where I was out there. It was kind of a rainy, ugly day. That was 9 months ago. 9 months ago, when that we posted that little clip, and it was me and nobody else out there.
Right.
9 months ago. And you know how many
Wow.
views we had for that? 470.
How many views? 470. That was it.
Yeah, 470. Yeah, that would not be very good.
We were youngsters
It was
9 months ago.
Yeah.
Yeah. Now we're just tired youngsters.
Yeah, now we're moving from young to retired very quickly.
Like the rats are.
I'm bowing out of the rats. Rats. Okay, let me find this document before we go too far afield here. So, I called yesterday and talked to my friend at the SJC, and they're like, "Nope, nothing's been filed. And I mentioned that on one of the shorts that I posted. And then this morning, got up and bing, and I sent a note to Tim Bradl as well.
Kelsey. This is on Kelsey Fitzsimmons.
Yeah, Kelsey Fitzsimmons. I said, nobody's telling me nothing. What have you heard? And he said, no, I haven't heard anything either. So then, bright and early this morning, I call back to my buddy at the clerk's office. I said, so can you fill me in on, what's actually happening? He said, wait a minute, I didn't even know anything happened. And he opens it up and says, oh, hey, you're right. I said, well, okay.
I know about that.
Yeah, so he's got a lot of things going on. Don't judge.
No, I'm not judging. But that's hysterical. Actually.
So I'm going to share this.
Tubi's a little incensed
Tubi
again
is
today.
not happy with that.
Tubi
was blamed for what happened the other day when I think I said bullshit to whatever we were watching or doing, and Domino was right here and heard just that, and that. So Domino goes off, and somebody said, "No, I think that was Tubi." So that was bad to witness identification.
Yeah, it was wrongful conviction.
It was. And speaking of that, that's a good segue. I did the interview with Justin Brooks today for the Justice Served TV True Crime Book Club for his book, which is called "You Might Go to Prison Even Though You're Innocent." It was great. It was fun. That's going to post for members tomorrow, probably midday-ish. And then maybe a couple of weeks down the road, we'll flip it. So we'll do that every couple of weeks, I think. I'm thinking of getting Jodine Weber for the next one because she's got a great book, which is kind of a fiction but has a lot of her life in it. An interesting book. Okay, so here we are. This is the order, and this is interestingly they did post this on the docket, so it's a little bit unusual that they put the order right there. So a little background: Kelsey Fitzsimmons indicted for one count of assault with a dangerous weapon. The dangerousness hearing was held on August 28, 2025 in the Essex Division of the Superior Court. We know who that was, right? Judge McCarthy. In an order dated that same day, the hearing judge found Fitzsimmons to be dangerous, but released her on conditions including, I always liked this when I think our law school newspaper or something was called Inter alia. Inter alia, among other things, that she abstain from alcohol and be subject to certain testing for alcohol use. The 58A order, and that's important, 58A, was temporarily stayed until September 8, 2025, when an order issued releasing Fitzsimmons subject to the imposed conditions. So then we go to September 10 of this year. Fitzsimmons moves for relief from the condition that she be subject to certain testing for alcohol use. After a hearing held the following day, the hearing judge, McCarthy, concluded that because Fitzsimmons could not comply with the alcohol testing as ordered, her release would endanger the safety of another person or the community. Now, remember, this is just a recitation by the appellate court of what they've read at the trial. This is not an independent understanding of what happened. These are just the facts as they've been made available to them. And they're certainly going to dig much more deeply into this. Consequently, the hearing judge vacated the prior order of release and ordered Fitzsimmons held without bail. Fitzsimmons then filed a petition in the county court seeking relief from the order of commitment. She further asked the judge, a single justice, and we know who that was, right? Dewar.
Judge
Dewar.
Previously known as Justice Dewar.
But now
is Justice Dewar, it
Dewar.
turns out.
Yeah.
Your friend did correct you and correct our pronunciation.
Yep. I appreciate that as well, and I thought it was funny that he had the insight on the liquor. Anyway, except
that we had somebody in our chat who's a co-owner of a liquor brand.
Really?
So yes, you're gonna get in touch. Gonna put you in touch. Missy has all. Missy, we may need a sponsorship. Missy has all the deets.
Okay, good. Let's see. The single justice denied the petition and the Fitzsimmons appeals. The case is now before us under this particular rule, which applies to a petitioner appealing from a decision of a single justice denying relief from an interlocutory ruling of the trial court. The rule requires a petitioner to set forth the reasons why review of the trial court decision cannot adequately be obtained on appeal from any final adverse judgment in the trial court or by any other available means. In other words, you got to exhaust all these other remedies.
Right.
Based on the record, we are persuaded that the appeal should proceed. Filing a petition pursuant to the code is the proper means for seeking relief from pretrial detention based on dangerousness in the Superior Court. Remember, the dangerousness is against Officer Noonan and the community. That's the analysis.
Because the dangerousness, because if she drinks, supposedly she will go out shooting, even though the facts of the case was that she was in her own house when her baby was ripped away from her. She's breastfeeding this child, not at the time, but she's breastfeeding the child. She goes upstairs, and then there's a dispute of facts as to whether or not she was trying to end her own life or whether she took aim at Officer Noonan. So my point is that the alcohol consumption has nothing to do with the facts of the case, and yet we're talking about her dangerousness in this order.
Yes, and there was some history. There was a bridal shower. There was some social event or two that in which alcohol was consumed. Crazy idea, but yeah, this judge has decided that was going to be a condition of her release. And now, if she can't do that test, then the safest place for everybody is for her to be in jail. The parties, so they reference the code in the cases Mendoza versus Commonwealth. As Fitzsimmons has no other means of obtaining adequate appellate relief of the pretrial detention order, this appeal may proceed with full briefing in the ordinary course. Now, that may just sound like, oh, okay, so that's not very normal. Normally, what happens is they take whatever was presented to the single justice and they review that as a panel. Nope, this time they're basically looking at this as a brand new process. And so there's going to be a briefing schedule. The party shall confer with the clerk to arrange an appropriate briefing schedule. Now,
which is a win for Tim Bradl, because he had said as one of the causes of action for his appeal, and I'm just saying causes of action, that's not the formal technical legal term, was that the judge below, Judge
McCarthy,
right? Judge McCarthy had done something wrong, had made the wrong decision, and then when it went up to Justice Dewar, Justice Dewar, she had used the wrong standard and didn't do a de novo review. So by having a briefing schedule, Michael, that's a whole de novo briefing schedule anew.
Yeah, and it is unusual. And what we're waiting for now, and I talked to Tim Bradl about it. I said, what do you think the schedule is to get the schedule? And he said today, and I've not seen anything on the docket, but it probably wouldn't be on the docket. Maybe they'd make a notation. Maybe that would just be handled in-house. But he said today or tomorrow at the latest. So what they're trying to do, obviously, the Fitzsimmons representatives are, motivated to get this in front of the court as soon as possible. We don't know what the prosecution's position is on this. Are they going to be limp-wristed like they were at the hearing where they did really nothing? Or are they going to be, more like they presented themselves in the brief to the single justice, which was much more in your face, much more we're right, they're wrong, much more we're doing the right thing by keeping her in jail? We don't know. But that's going to manifest itself in these briefing dates. Now, on October 27, Fitzsimmons files a motion to expedite in which she requested that the court grant oral argument and expedite a hearing. The request for oral argument is hereby denied without prejudice as premature. So what the court is saying is, we aren't even going to know whether you deserve really an oral argument until we see these briefs and we see where we're going. And the court, I'm getting the feeling because of this decision asking for a full hearing and further briefing that they are going to want oral argument. Just a thought. Maybe I'm dead wrong, but it seems to me they're going the extra mile to look at this as closely and as seriously as they can.
Well, yeah, and if they do that, then this is the Massachusetts Supreme Court, the Supreme Judicial Court. It's their their SCOTUS, so to speak, right? Then it's interesting because then they'll have a written decision, and they may be thinking far beyond in terms of what we think this case is about. They may be talking about maybe some type of substantive due process, because Tim did raise that in his appeal about constitutional issues. So he does have those preserved here.
Yeah, no, I think they've done all the right things to get the attention they need. In crafting an appropriate briefing schedule, the clerk shall give due consideration to the time sensitivity of this matter. So again, the clerk plays sort of referee in this, and both sides are going to submit dates. Clerk's going to work with them, and they're going to come up with something that everybody is happy with. We express no view on the merits of Fitzsimmons' claims at this preliminary juncture. So.
And I think I said that to you. I said when I was walking back to my office, I said the problem I have with all this right now, though, is that we're approaching Thanksgiving and Christmas, and she is still in jail when she went in and just sought modification of the manner and means of which she can comply with the Scram breathing test. And by the way, for all of you that forget, we still have Justice Serve TV. Has agreed to foot the bill for any alternative means of testing for her, if that will help get her out.
Yep. And, it's really just a function of what's the alternative going to be, and let's get it going. I did a little bit of research on the panel. We'll talk about it more at some later date. But I thought it was interesting. The Chief Justice is Kimberly Budd. And I've got pictures and everything of these folks, but we'll get into that some other time because I want to get into this teacher shooting case. But one thing I found interesting about her, and this will be a flashback to some of the materials that were presented by Tim Bradl. Remember the ADA argument? And there's some suggestion that was premature because they needed to exhaust an administrative remedy on that.
That's the Americans with Disabilities Act. Everyone,
yes.
People aren't familiar.
And I'm looking at her judicial, basically it's her resume. She worked on a number of ADA cases prior to her becoming the Chief Justice. I don't know. Does that mean anything? Is it going to matter? Is it going to impact what ultimately she decides or argues when her panel is discussing this? I don't know. Frank Graziano is another one of the members of the panel. And let's see, Scott Kafker is one of the panel members. Sergey Jorges Jr. is one of the panel members. And of course, who will not be on the panel?
Justice Dewar.
Yes, that's all. Basically, they set her aside, so that leaves the 6 to remain and discuss this matter. So hopefully it'll be set up. I mean, it's not inconceivable that it's briefed by the end of this month. That's not inconceivable.
Right.
And if that's true, maybe they resolve this before the second batch of holidays. She's stuck in there for Thanksgiving, but maybe gets out before Christmas. So
I tell you what, this is just, I mean, this whole story, I mean, this is unbelievable. This is unbelievable. I just have no words for how you can go in proactively to try to get something changed and end up, and that's after you get shot in the chest, after your baby gets taken away, and end up in jail. And it's very, very scary. I mean, to say the least. I mean, that's the only thing I can put on this. It's a horror show.
Yeah, and that's what makes it even more aggravating is that it wasn't a situation where she violated conditions and they were trying to massage that and keep her out. No, she went in on her own to say, look, this is a pain, literally. Let's do something less painful. And you end up back in jail. And again, as her dad told me, she's not in general population in that facility, which is a massive facility out there in Chicopee. We were out there one night doing the show. So she's, that has its pluses and minuses, right? You're not really in protective custody per se, but you're sheltered away from the others, which socially is painful, but probably best. Right? Doesn't make it fun. She's out maybe 1 hour a day, right? There's no good solution. But if that keeps her safe, then obviously that's what you want to do. Okay. So that's the
update. That's the update. And we'll know more tomorrow. By the time we do our show tomorrow night, we'll know more. And by the way, Massachusetts did this, even though today was in many states a court holiday.
Yeah, that's true. But I'll give Massachusetts credit for that they kept the fires burning on a holiday. Let's talk now about Zwerner versus Parker. Now, we saw this coming along.
Right.
Didn't really get our attention until it started to unfold. This is the story of the first grade teacher, and that's Abigail Zwerner, who was shot back on January 6th, 2023, by a 6-year-old in her class who brought a gun to class. Shot her. She was in the classroom. We'll get into the backstory, but the bottom line, the incident, this young kid comes up to her, points the gun at her. She, tries to, kind of protect herself in whatever way we normally would. She puts her hand up. She gets shot in the hand, and then the bullet goes into her body, upper body, just misses her heart, ends up in her shoulder, and not unlike Kelsey Fitzsimmons, has bullet fragments still in there, which are likely to remain. This is a civil lawsuit. And before we get into some of that, it's weird because the defendant in this case, and that's Ebony Parker, she was the former assistant principal. Most folks know in schools, whether it's K through 5, whether it's secondary, the assistant principal is the disciplinarian in the system. That's the person, given that job, okay, which is key, I think, in this case, because if you're talking about a suspected gun in the school, she'd be the one you would think that would be on top of that. She's facing 8 felony charges as well for child neglect. But that trial is not happening till next month after the civil trial.
Yeah, that's what I wanted to ask you about. Usually the civil trials are stayed because they have to testify. Why is the civil trial going on when she has a Fifth Amendment right to remain silent? Because there's a criminal trial coming on. I didn't understand that, Michael.
I'm not sure either. There are some theories. One of them would be that this gives the defense in the criminal trial a little sneak peek at the prosecution's case, a la the plaintiff's case in this civil matter. Witnesses, you don't have to pay for depositions because they're testifying in the trial. So sure. there's some benefit. I don't know if it outweighs the risks, but there's some benefit to learning more about the case prior to going to the criminal court. Obviously, if there is liability found and money is awarded, it's not going to matter in the criminal case because the burden of proof is so much higher in the criminal case. But it is odd to see that the civil case come before the criminal.
Because she testified. Ebony Parker testified, right?
No, she did not.
She did not testify.
Here's what's interesting.
That's what's okay.
During the jury instruction conference, which began yesterday afternoon, and they're going to complete it tomorrow morning. They are off today because of the election.
Right.
But they're going back tomorrow morning. They're going to wrap up. They had a couple of sticking points on a couple of instructions. Then the court will instruct the jury first, then closing arguments, and then they'll begin to deliberate. A lot of people think this is going to be done by tomorrow afternoon, or I don't know. I mean, from what I've seen, I don't think it's as close a call as many might think on first blush. But this instruction that was being argued about had to do with whether she testified, and there's that instruction that says claiming the Fifth shouldn't be held against you, and the jury is told the fact that the defendant, normally in a criminal case, did not take the stand and did not testify cannot be held against that person, right? Well, that was requested because the defense wanted that feeling that don't hold it against my client because she didn't testify. The court said, no, you can't have that. This is not a criminal matter. She didn't get on the stand and say, I take the Fifth. If she had done that, then the court would have allowed that instruction. But she didn't.
Except that you can't do it in front of a jury. You can never take the Fifth in front of a jury. So I was confused. This whole thing confused me in Virginia procedure.
I think if there would have been some sort of proffer with her on the stand, and during that, with the jury's gone, the judge heard her take the Fifth, that he would have allowed the instruction, but then the jury wouldn't have heard her take the Fifth. So I don't know how he would have massaged that. Worked out fine because she didn't take the stand, and she never was asked whether or not she would testify. If not,
right,
what was the basis for not testifying? So, okay. So the most important witness, obviously, the plaintiff, right? And I have a couple of pieces of tape. First, we're going to look at obviously the testimony. But 2 years ago, remember this happened, January 2023. Just a few weeks after that happened, she was on the Today Show with my friend Savannah Guthrie. Savannah and I worked together at Court TV, and she went on to the Today Show. I went from Court TV to Long Crime to here, so I feel sorry for her. I feel sorry for her
you with me.
that we're doing this, and she's stuck at the Today Show. But she's a great person. I like her a heck of a lot.
Yeah, that's
I
hysterical.
remember one day we were in Washington. We were covering the Massawi trial. Remember the Massawi trial?
No, I
the
remember the
extra
Massawi trial.
bomber, 9/11. And so we're hanging out afterwards, chatting. And she had been approached by CNN and NBC, and CNN was going to give her like a pretty high platform, and NBC was giving her, a very entry level thing. And I said, "There's not even a question. Take the NBC deal." Once they see who you are, what you are, because she was an attorney, she worked in Washington, she had brought all these things to the mix, and obviously she went to NBC, and I get a check every month because of that. No, so she made the right choice.
Instead, you get me
Right. Well, that's invaluable. And the CNN folks, and I can't remember who it was at the time, who was running that circus at the time, but they were basically trying to shame her for not. This is CNN, and you'll have this high profile, and well, look where she'd be now. Just anyway, I'm glad it all worked out.
Savannah's also, people don't realize she's like 6'1". She's very tall.
She is pretty tall. Yeah, she is pretty tall.
She's very nice, also a very lovely person.
Yeah. So this is an interview she gave, or she had, with the plaintiff. Let me see if I can find my buttons here. Oh, there we go. I want to play just a couple of minutes of this so you get a feel for the plaintiff at or about the time this happened. Okay. Now it's a crapshoot as to whether you can hear this.
Talk first about
Can you hear?
Yes, we're good.
How is your recovery going?
I've been doing okay. I've gone through a lot of obstacles and challenges. Some days are not so good days where I can't get up out of bed. Some days are better than others where I'm able to get out of bed and make it to my appointment. But, from going through what I've gone through, I try to stay positive, try to have a positive outlook on what's happened and where my future's heading.
You just had a surgery on your hand. What are the physical injuries?
The initial gunshot went through my left hand and ruptured the middle bone as well as the index finger and the thumb. The gunshot then went into my chest up here where it actually still remains. So I have a scar up here and I still have some bullet fragments up here.
So part of that bullet is still there.
Yes.
Do you think it will always be there, or do they think they'll remove it someday?
I think it'll always be there.
I asked you a lot about the wounds that we can see, but there are wounds that we can't see.
Yes.
How are you doing?
Well, I guess we'll never know because I'm not going to watch that commercial. So,
but it's interesting that you point that, because yesterday, the defense, as we all know, when you try a case, you have to, it's an attack on liability, but also the defense will also attack whether or not someone has damages. And they were attacking whether or not she has those psychological damages that have been pleaded in the complaint. Because they did a smart move on behalf of the plaintiff. They didn't, they pleaded them as, and I won't want to say ordinary, but usual garden variety pain and suffering and all, so that she doesn't get interrogated by a defense examiner, right? So that the person was able to go on and talk about pain and suffering, but wasn't able to say, the expert for the defense, that they had interviewed her. So, people are going to say, so how can you really talk about her? You're going to say that she's not damaged? Come on, she was shot.
Yeah. And they tried to go at her too because she left teaching, not surprisingly, and went to cosmetology school.
Not surprising, I would too.
And that's very, dexterity related. And so how you doing that when your left hand is all mangled? That's a factor, and it's legitimate. I mean, the jury should weigh that. If there was testimony that she never ever was able to use her hand again, that's one level of damages. If it hurts to do things like cut hair, that's a different level of damages. So they had that information, and then there was a gym that she would go to quite often that they kind of attacked her on. Well, how bad can it be? You're going to this gym, right? But physical therapy takes place in a similar setting, and you're doing that to get better. So, but those were the attacks. Here's something I want to talk about before we get into her testimony. And we don't get into this much because we don't do a lot of civil stuff. But there are two kinds. This is a typical negligence case, meaning in this case, assistant principal owed a duty to this teacher to protect her from a kid in the school with a gun. That's shorthand. the thing is, let's assume all those things are found, that there is a duty, and that the failure of this assistant principal to do anything directly led to the shooting, right?
Right.
And now we're getting to whatever the damages might be. But it's possible to have contributory factors in any sort of negligence action. In some states, they have what's called comparative fault. So you do something and it's 50% your fault, 50% my fault, but they still believe I should get something. So that $1 million awarded is basically $500,000. Okay. They pare it down based on comparative fault. Not all states are like that. Virginia, and this is
as long as you're not 50.1%
yes, that's right,
liable as a plaintiff, then you get to recover that 50, the 50%. But if you become
and in most cases
50.1% liable, then it's a bar.
Right. And my example is bad because it's never usually 50. It's usually like 20% or 13% or 50%. I mean, 15%. It's not as clean. But in Newport News, Virginia, they have what's called contributory negligence is the analysis. And that means if the plaintiff is found to be negligent at all in what led to her injuries, then she doesn't recover.
At all.
At all. And so that's why I'm very interested in the jury instructions I watched yesterday, and I don't think they really dealt with it all that closely. The jury doesn't normally hear those things. That they would be asked who was negligent, and then you might have to assign a percentage to it, right? And if they assign 0 to Ms. Zwerner, good for her. But if they assign 5%,
she gets barred, and the jury is not told the effect.
The
jury's not told the effect, so they're going to go in there, and they will be asked to assign a percentage, if any, that the plaintiff is negligent, and they don't know the ramifications. There's going to be a fight over that, by the way.
No doubt.
There's no doubt. It's going to be a fight over that, because that's always a fight over that in negligence cases that are not comparative negligence, that are contributory negligence.
Yeah, and it's really the less popular way to handle negligence, but it still exists, obviously. So let's look at some of her testimony. She was only on the stand for about an hour. We'll watch some chunks of it here. Let me get this. Again, this is Abigail, also known as Abby. She taught first grade, 5 and 6-year-olds for about 2.5 years. Okay,
correct.
Hold on. Let me start you back here.
My name is Abigail Zwerner. And Abby, how are you feeling right now? I think nervous is a big one. Nervous, anxious, a lot. And Abby, the jury's already heard a little bit about yourself from your mother and your sister. So just tell the jury, how long were you a teacher?
About 2.5 years.
And where did you teach at during that 2.5 year period?
Rich Neck Elementary.
Tell the jury what grades you taught.
I came into 4th grade, my first year of teaching. That was when we had the virtual hybrid year. And then the following 2 years, I taught 1st grade, all at Rich Neck.
And how did you enjoy teaching?
I liked it. I do remember it was stressful a lot of times. Being a new teacher, a lot of new experiences, a lot of ups and downs, I remember. Yeah.
And now, Abby, I'm just going to ask you a few questions about January 6, 2023, okay?
Okay.
So tell the jury, when on that day did you first hear about JT might have a gun?
It was before recess.
And do you remember who told you that?
Amy Kovac.
And when Amy Kovac told you that, why did you not go to Dr. Parker?
I knew that she was going to tell Dr. Parker.
Did Amy tell you she was going to tell Dr. Parker?
Yes, she told me that she was going to tell Dr. Parker.
This is so important, right?
Very important.
This goes to, the notice and whether or not something should have been done that wasn't done. The teacher did not go directly to Ebony Parker and say, look, here's the situation. She relied on this intermediary to do that. That's going to be huge. That in itself,
the issue is, and I'm going to pose that to you, Michael, is she contributory negligent with herself getting shot because she didn't go to the assistant principal and just relied on the word of somebody else that was allegedly was going.
yeah, that's, to me, if I'm in the jury room, that's going to trouble me. that she was in the best position, the kids in her class, to protect herself once that information became known that there might be a gun and this little kid might have it, 6-year-old JT, and she didn't. And I don't know if I could get past that to find her totally faultless, as much as I'm sympathetic to what happened. I know it's probably not a popular position, but that's I think that's not totally unlikely.
And did Amy tell you that 2 girls had advised her of the fact that JT might have a firearm?
Yes.
Do you know who the 2 girls were?
I did not.
So she didn't even tell you which kids in the class had told her that?
She did not tell me.
And no other kids told you?
No.
Okay. So you heard it from Amy, and Amy said she was going to tell Dr. Parker at that time?
Yes.
Were you told to keep an eye on JT by Amy?
Yes.
And is that why you were texting and communicating with Amy during recess?
Yes.
And is that why you texted Amy about what you observed JT doing before recess?
Yes, because I knew that once Amy had informed me of the information that the students had told her, I knew that Amy was going to then relay the information to Dr. Parker.
And again, no one else had told you anything about a gun besides Amy.
Correct.
And Your Honor, I would like to publish and pull back up what's already been submitted as Plaintiff's Exhibit 3, if that's okay with Your Honor.
Which is that?
That is the picture yesterday of Abby. Shirt. Oh, 90C. Is it 90C? I'm being corrected that it's Plaintiff's Exhibit 90C, Judge.
Okay. Any objection to that?
No objection.
Right. It's already been admitted, correct?
Yes, it's already been
All right,
admitted,
got
Your
it.
Honor.
Yep.
And Abby, do you recognize that photo? It's on the screen in front of you.
Yes.
And what year is that from? Do you know?
I have slightly orange hair. Looks like it's washed out. So it would have been the 2022-2023 school year.
So you're in your first grade classroom, room 11?
Yes.
And if we can zoom in on the orange sheets that are behind your head, do you see those?
Yes, I do.
Can you tell the jury what is that?
That would be our handbook, our school's handbook. I believe it was titled the Crisis Management Plan. I may be wrong on the title of it, but it was the tier 1, tier 2, tier 3.
So that's the school, that's a handbook that you would reference?
Yes.
And why would you reference that sheet?
For the behaviors, it was like a left and right side.
And why would you look at that, the left and right side?
The like possible displayed behaviors on the left, and then on the right side, actions to take as a teacher.
And Reed, if we can only display to council, please, Exhibit 108, and it would be date stamp 9074 and 9075. Thank you. And Abby, do you see 2 documents in front of you?
Yes.
Do you recognize those 2 documents?
Yes.
And what are those 2 documents in front of you?
The on the left and the right side, it looks like the 3. I don't know how to explain it. It's like the combined on the one sheet of paper. that I had on the orange sheet of paper, like the level 1 behaviors, and then on the right side of the screen, level 2, and then level 3 behaviors. I had that all on one sheet of paper, the orange paper on the wall.
So the exhibit that we just showed to the jury, the box that you had of the 3 tiers, is from this document?
Yes.
Your Honor, at this time, I would move to submit this document as Plaintiff's 108, and we would mark it as 108.
All right, any objection?
Object, Your Honor. This witness can't authenticate. This is a handbook from Rich Neck Elementary. She's not an employee. She can't authenticate the document.
Well, she's identified it. That's overruled.
Thank you, Your Honor.
All right, so admitted.
Thank you.
Plaintiff's 108.
May I have permission to publish it to the jury, please?
You may.
Thank you. And Abby, we're now sharing this with the jury. So can you tell them again where this section 3 came from?
The Rich Tech Elementary School handbook.
And the chart that the jury is seeing on those 2 pages, is that what was combined into one chart in the photo that we had just previously showed the jury?
Yes.
So this is important because it's setting up the, what was the proper procedure and the behaviors that might trigger that procedure. Let's talk about her for a second. My initial reaction when I heard her was that she sounds so young. Not, and she is young because I'm old, but I mean, she sounds like almost, just younger than her years. I'll put it that way.
I think it's a little stilted because it's clear to me that they've got some kind of agreement with the court and all as to hearsay testimony here, because she's testifying as to hearsay testimony, and they're trying not to overstep out of that. So I think it's a little stilted because of that. That's my impression.
I just feel like her demeanor is, and she mentioned how it was very stressful when she started teaching. I can't even imagine. But I put that demeanor in the context of what happened that day. And it makes it more likely in my mind that she would not be the type of person that would be more aggressive in pursuing some, is there a gun? Is there not a gun? The guy's in my class. She just doesn't seem to me proactive enough, just based on, this demeanor, how she's interacting with, this is on direct. And it wasn't much different on cross. Cross was very short as well. I'd suggest folks take a look at that if they have some interest in the case. We're not going to be able to go through the whole thing. But I wonder what the jury does with that.
I think it's a first grade teacher. She's got to relate to these young kids. She can't be like an Attila the Hun. So I don't have a problem with her demeanor at all. I think that the more I have a problem with is that is the defense advancing to the jury that it's not just Ebony Parker, it's everybody's responsibility to report these behaviors. It's everybody's responsibility. But if I recall, there was testimony in this trial that the school said they couldn't look at this kid's locker because he had privacy interests, and the school also advanced as something that I think is absolutely outrageous. And sometimes your best argument from a plaintiff comes from the defense theory when they say that it was not reasonably foreseeable that a 6-year-old would have a gun. Well, if you live in today's world, it's foreseeably reasonable that a 3-year-old could have a gun.
Here, they had their expert, the defense expert was on yesterday. And on cross, she was asked to rank, the likelihood that somebody would have a gun in these different scenarios. And there were facts that were added to the scenario and to see how that would affect her fear that there might be a gun, or the foreseeability was the word they kept using, which of course is key to any negligence case. Was the action foreseeable? And she started at a 1 because it's K through 5. And she contrasted that with, secondary might be a higher number. And then as they started talking about, then there was talk that somebody might have a weapon, and then that it might be a gun, but is it a real gun or a fake gun? Then it elevated, but it never got above 2 to 3 on her 0 to 10 scale in terms of foreseeability. Therefore, of course, she found that Ebony Parker had done nothing wrong, that she was well within her duty to this teacher to do what she did, which was very little. She didn't get up from her desk, go out and, go to the room, check on the kid. She really didn't do anything.
Nothing as far as I'm concerned. I have no problem with her affect. She's been shot, just like I would have no problem with Kelsey Fitzsimmons' affect. She's, when you're jumping from being a teacher, when you have to love to be a teacher, they're committed.
Yeah.
And I don't mean committed into a mental institution. I mean committed in terms of what they're doing to cosmetologists, which I absolutely love. I love my hairdresser. I love my makeup. I mean, I love them to death. And they're very that's very stressful too. But she's completely changed professions here. And I think that just goes to show you that she has problems with what happened. I mean, look, you would too, Michael. I mean,
no doubt about it. And so
Yeah.
I'm probably, taking what we see now and thinking that's exactly how she was then. I don't know. This event may have made her, a little more demure and a little more meek.
Well, her job wasn't. She wasn't an assistant principal. I mean,
she
the school tells you they can't search the kid's locker. They can't. They have privacy issues. They can't search it. He just attacked her things. Not that he attacked her. He attacked her things. The kid was a problem kid, and there's a report now from 2 people that he has a gun. And by the way, somebody asked whether or not anyone was charged. His mother was charged, and I think received 4 years in prison for the gun. Right. But so I mean, on those situations, is it an avoidable shooting? Yeah, I think it's the school could have avoided this shooting. I mean, I think that's exactly it. And when you start giving me garbage that you couldn't foresee a child of 6 years having a gun, 6 years old having a gun, you've lost me as a jury. I mean,
well, I think going in, I don't disagree with her going in, because contrasting primary grades or secondary, that's a different level. A 6 or 17-year-old, 18-year-old, I could foresee them having a gun much more so than a 6-year-old. I don't have a problem with that. But when you start hearing what they apparently heard that day, which was, does little Jimmy, that's not his name, have a weapon, and then it became maybe it's a gun. Then they searched the backpack and couldn't find anything. And there was some suggestion that he might have put it in his pocket, but he's a little kid and the pockets are small. And so there was some question about where it actually ended up. But all that stuff takes it to a different level of foreseeability. Now you're talking about an actual weapon somewhere in the school. It's just a whole different deal. And I think that's where they went astray. And that's what the defendant is being blamed for. So
let's look bad for it. And I see some of our chats saying, they can't believe it. But yeah, what do you think schools are doing? When you go outside, kids take out guns at their house that are 6 years old. We see those shootings all the time. So I live here in New York City. I don't see any problem. I just assume everybody on the street would have.
Well, you may be a little jaded then, because I don't think that's true of everybody across the country. And even in like a small town which is outside of New York in Westchester County, where our youngsters went to school at the time, they have metal detectors.
Right.
And so is it too bad when that becomes the norm? Yeah. But if it helps prevent even one shooting, do it. In the words of Alan Jackson, do it.
Yeah, do it. I see Lindsay Bay has that's ridiculous. I don't think it's ridiculous at all to say that a 6-year-old could have a gun. There's reports of the 6-year-old having the gun. Once you have reports of a 6-year-old having the gun, to say the 6-year-old didn't have the gun is, I think that's ridiculous. Because
well, that's what I'm saying. That's a whole different level. To go in assuming that every 6-year-old could have a gun, I think that's wrong. But
I
once
think there's a report, right?
Once there's
a report, that's different. That's the whole point. There's a report here. Two people told Amy that he has a gun.
Yeah, or something. I mean, there was enough that you should have investigated. It's a weapon. Is it a gun? Is it a real gun? Is it a fake gun? I want to just watch another couple of minutes of her before we move on.
Ms. Werner, at some point on January 6th, did a student named R tell you that JT had a gun?
No.
Do you don't recall saying, save it for later or sit down to that student?
No.
That didn't happen?
No.
And the first time you saw JT with a gun, he was at his desk. Is that correct?
Yes.
The first time you saw a gun that day.
Yes.
And when you saw that, you were shocked.
Yes.
Because you didn't expect to see that, did you?
It was a real gun. Yes.
Is there a point where you didn't think he might have a real gun?
Well, the whole day I was contemplating it could be real, but it also could not. When you hear the word, oh, he told students he brought a gun with him to school, there is that possibility.
Ms. Werner, you were asked about the staff handbook. Can you pull up, it's, what exhibit is this? Is it
108.
108? 108?
Let me move on from the staff handbook.
Yeah, and Lindsay, I agree with you. I think the saying that you can't search
At
your locker,
84.
I think it's ridiculous. I think it's closing your eyes to the fact that you have real reports here of a gun.
Well, and to that point, I think her testimony on that Q&A hurts her case, because she's saying that at some point earlier in the day, I think it was around recess, and this happened at about 12:30, she had heard all of these stories and was wondering, oh, he has a gun. I wonder if it's a real gun. I wonder if it's a fake gun. Why aren't you doing something about it? Rather
Well,
than
do you know
just
if Amy? But if
whispering?
do you know if Amy had already reported it? And then the question is not why aren't you doing something about it? Because she's a teacher. Why isn't the administration doing something about it?
I would have gone, if I were the teacher, I would be marching down to Miss Parker's and tell the teacher across the street, keep an eye on across the hall, keep an eye on my kids. I would be in Miss Parker's face saying, it sounds like Jimmy, not his name, has something, a gun or weapon. What are we going to do? I just would be that proactive. And I don't know if a jury will hold against her that she wasn't that proactive. I don't know.
Let me ask you this: do you think there's a difference between a man and a woman? What you would do in the
I don't think so. I think there's a difference in personalities, but I wouldn't make it sex-based. There are some guys that would be more timid about it, some guys that wouldn't be. There are some women that'd be more timid about it, like she seems to be, and there are some women that wouldn't be. So I think it's more personality, not sex.
Interesting, because I also think that has something to do with, Parker is her supervisor, whereas Amy is not, and Amy said she was going to go tell Parker. So,
I just in that position, if you're thinking like she said she was thinking, I wondered if it was a real gun or not. I'm not relying on anybody else. I'm getting my ass down the hall to the assistant principal and saying, let's fix this, because even if it's a toy gun, who cares? We need to find out. Right?
Madeira Beach caregiver has an interesting take. This is insane. Think of how much worse this could have been. Let me just star this so I can grab it a second. Think of how much this could have been, worse this could have been. Other students getting possibly shot. I'm appalled she did nothing. Shame on her. Everyone knows today's world is crazy. But the question is her making sure that Amy did. Amy said she was going to go do it. So, I know.
I just think in that scenario, maybe I'm a control freak, but in that scenario, I'm not relying on anybody to do anything when I'm in the classroom with what could be a gun. I can't excuse that. I don't know to what degree it makes her at fault, but as we've said, contributory negligence state, it could foreclose any recovery. So
let me give you the additional fact. I mean, they said they searched his backpack. They don't find anything.
Yep.
So she's worried whether he had a gun or not. But the administration says they've done all they could do. They searched his backpack. They don't find anything. They can't search a locker because he's got a right of privacy in the locker. And what's she to do? Was she to break down the locker?
Well, I think at that point when they thought that he might have put it in his pocket, or it didn't answer all the questions about the gun. It suggested it's not in his backpack, but it doesn't mean somebody thought he put it in his pocket, which continues to leave open the possibility there is a gun. Now we know it's not in his backpack. I still think there's more you need to do on all levels. But if I'm the teacher in that room, I'm on it. I'm not relying on anybody. Let's see if we can see a little more from her here before we call it a day.
I've read it.
Hold on 1 second.
While you're finding that, though, does the school, though, when they come back and they put an expert on the stand, which they had yesterday, Dr. Amy Klinger, to say that it would be difficult for anyone to foresee the incident, do they then just gut their own case of whether or not your argument that the plaintiff should have been more proactive? Because they're saying, well, no one could foresee the incident. So if no one could foresee it, she couldn't foresee it either.
Yeah, well, that's why,
So
obviously,
foreign
that's why,
document.
expert testimony is so critical. If I'm listening to that expert, I'm not believing her. At the point where a gun is in the conversation, I'm not going from DEFCON 4 to DEFCON 1, but I'm moving it up far beyond. Foreseeability goes from a 1 to maybe a 2 or a 3. I think it goes to a 6. I think 6 is more likely than not. And when I've heard people say, hey, little Jimmy, not his name, has a gun, your foreseeability now is not the universe of K through 5 schools, right? It's
No,
now
it's
not this school. It's your freaking classroom,
It's
and
your-
it's potentially one person.
Yeah,
your
but here
classroom.
you have it, and Rose is right. Amy did report it to Dr. Parker. That's why they searched his backpack. But that's the point. So she does think that it's reported, and then the question is, she's got to sit there teaching kids, saying, "Well, was it a gun? Is it not a gun?" Because the school's telling me they can't do anything more. So she's sitting. What does she do? She has to sit there and teach. She can't leave. She leaves, she loses her job. She doesn't know, and so she's got to sit there. I think it makes it worse for the school. I mean, I'm more sympathetic to her, I guess, as a
What
plaintiff.
I'm a little fuzzy on is the time frame between she sees the gun and he uses the gun. It's because there's going to be some period of time. I don't know what you do when you first see that gun on a student's desk. Do you distract the child? Kind of work your way over there. You don't want any of the other kids to be hurt, right? I mean, that's your primary concern, not for yourself. But I'm a little fuzzy about how that all played out, the actual time frame. And she's very, she doesn't recall very much about the actual incident. So I don't know if we got a lot of clarity on that time frame. Anybody else who may have heard this and missed something I missed, feel free to share.
Yeah.
But I think it was a little fuzzy as to from the point she sees there's a gun to the point she's shot, what's going on.
Yeah, Madeira Beach says she shouldn't assume anything ever.
Yeah.
And let me just interject one thing, a funny thing here, Brielle BB. Linda, I didn't know why I only realized today that you're married to the Dr. Michael Button. Okay. He's been on the show. He's been on the show.
I prefer to think that he's married to the Linda Kenney Baden.
Oh, thank you, Michael Bryant. That's my great streaming partner.
Yes, sir.
All right, any objection to the entire document?
Okay. Document.
All right.
I think we're pretty much done with. I suggest anybody. I'm all in on this case now.
Correct.
So it's a perfect primer too for the federal case. The criminal case that's coming up. And so before we say ta-ta for the evening, let me hit a couple of high points on this case, because the questions I had were who else was the defendant, right? Clearly, it couldn't have been just the assistant principal, who, by the way, resigned about 2 weeks after this happened. It was also the school district, not surprisingly. It was also the school board and also the former school superintendent. All were dismissed after a summary judgment motion. Summary judgment motion, for folks who can't recall, is basically like, I used to describe it as a paper trial. So you've had some discovery, some depositions, some requests for admissions, all those little interrogatories, those things. And you take that information, you plop it on paper, you present it to the court saying, here's the evidence. This is the state of the evidence. This ain't going to change at trial. Based on this evidence, my guy, or guys, in this case, the board, the principal, and the superintendent, we have no liability here. And that's what the trial court found. So they were dismissed out of the action, leaving Ms. Parker as the sole defendant. And you mentioned, you think about the kid. I mean, obviously the kid's got some issues. Why a kid thinks it's okay to bring a gun to school, who knows? But after the fact, his mom, Deja, she takes a plea deal and gets a 4-year stretch for, I think it was a federal gun charge. And then there were some state charges for child neglect, the same charges that are pending against Ms. Parker. And so she did her stretch in the federal system. Now she's finishing up in the state system. And Ms. Parker, just to put a bow on this whole thing, in the criminal matter, is looking at 8 counts of child neglect. Each is punishable by 1 to 5 years in prison. So, and that's going to happen in December.
Okay, so I assume that by the next time we meet, we will have either tomorrow night or by Thursday night, certainly, we will have a verdict in this case. And then the only fly in the ointment to me is this whole idea of contributory negligence. They found her 1% guilty of anything, of negligence. I don't mean guilty, but liable of negligence. She's barred from recovering. But I think that she will recover. I think the jury is going to award her something. That's my
And and on that front, the big number, the headline is she wants $40 million. She wants $40 million. Most states don't require that you put a number on your lawsuit.
Right.
I don't know if Virginia requires it, doesn't require it, allows it. I'm not sure but it became the headline when they put that number in the public's either in the complaint itself or in some arguments being made. But it's a big number. It's a very big number. So again, I'm all in on this. So we'll be doing this tomorrow. We'll probably have closings. It will kind of be on. We'll play it by ear. I'm not sure. I haven't really thought about the day's events. But if we can go live when the verdict comes in, if it does, we'll have to work this out.
We'll see. Our chat is certainly involved in this case. Those that are here are really involved in this case, I see. And it's good to know because obviously it raises some very important issues. And of course, I have not discussed the elephant in the room, and we all know what that is.
You want to discuss the elephant in the room? Because I'm not too bright.
No, I think the elephant in the room also has to do, and I'm going to say it out loud, has to do with race.
It has to do with what?
Race.
Oh, race.
R-A-C-E.
Oh, that's funny. I didn't even think of that. I mean, and I'm not trying to be holier than thou. I didn't think about it in the context of this case. One thing I did think about, remember the parents in Michigan? Was it Michigan?
Right, it was Michigan, right, who went to jail and they're seeking to overturn their
they had
seeking to overturn their
manslaughter charges because the kid had the gun that they knew about and blah blah blah. Older kid. But I thought about that in the context of this case. They did not pursue charges to that degree because obviously somebody's not dead. But again, the parent was charged with child neglect, not with anything that came as a result of the actual shooting. So interesting. Yeah, interesting case on many fronts, and that's kind of stuff we like to cover. So. Yeah. All right, then. Let's do that. Let's do that tomorrow. Okay.
Oh,
and Fitzsimmons update. We may have at least a schedule, if nothing else. And schedule, I think, will be telling. Yeah. If you missed that earlier, Kelsey Fitzsimmons, the full panel will hear their case. Not surprising. Going to hear new information. So a briefing schedule is going to be set, and we could learn about that as early as tomorrow.
And if you missed our show last night, Michael Easter, Data Daddy, we'll use both pronunciations, as some of you have named him, was here. And he's still on our YouTube page, garnering many views per hour. Okay,
people love the guy. He's he's
talking about Ian Whiffen and the interviewer Heather, who, by the way, is on. I see her being quoted in a number of news articles. As a matter of fact,
oh, really?
Yeah.
That's interesting.
So, a number of news articles because she and her husband supposedly are talking about the downloads that they did or the work they did on the Brian Kohberger case. That's going to make those videos more validated. I don't know. We'll see. But you have to listen to Mike Easter. Hopefully we can get him on again. Maybe someday we'll finish. He only got through like it was 4-page summary. So, but he was great.
I have to do this now. I'm audibleizing. I took a little bit of grief because I mentioned that Heather Barnhart should not have worn her hair pulled back.
You took grief from me.
Well, some folks have commented as well. I wasn't mean about. I didn't say she was unattractive. I said no woman looks her best when her hair is pulled back straight like that. That was all I said. That's about as honest.
That was enough. That was enough.
Apparently it was, but
you're like the cosmetologist, hairdresser from hell with that comment.
I've told my wife the same thing. It's great if maybe you're out in the yard doing stuff, but if you're going out, you're going to be.
But that's your wife. That's you can.
Well, I'm just saying that's how I feel about it. I'm not making stuff up. That's and I want to show you this. I wish I could find it more quickly than I've been able to. Let me see if I can find it.
Let me know when you find it, because I gave you grief about that when you said no. I said, oh, Michael, jeez,
Yeah. Where did it go?
Or it could be like the airlines who don't like women who wear leggings.
Oh, I've never heard that. I've not heard that.
Mm-hmm.
Curious.
You can't get upgraded to first class unless you're wearing a collared shirt. That seems to be almost sexist because most collared shirts.
Check that out.
Check what out?
This is Heather.
Yeah, I see, and she doesn't have her hair pulled back. So what does that mean? So
it's just a more approachable look.
it is
at that.
has nothing to do with
that.
being approachable.
Yes,
You-
this
Michael,
is, by the way, this was done just a couple of days ago. So she's
has
still there.
nothing-
This is
nothing
an
to do with-
in-house video, just like the others. And first of all, why are they putting these videos up and not
That's
making them
the
private?
question. That's the interesting question. See, when you talk about her looks, which is pulling her hair back, or her looks, it goes away from what we're trying to do, which is focus on these videos. But you know what? Everybody loves you because you speak your mind. So,
And
you
I know
there you go.
Missy was waiting for this.
Typical man.
Yeah. So anyway, there you go. I think I rest my case.
I think we rest ours.
Okay. That's going to do it for us. We are Justice Served TV. Hey,
Subscribe, like, share, notify.
and try to do the right thing.